Hey everybody, welcome to Law Hero. My name is Jen. So we are filming this at 6:15 in the evening and I'm absolutely wrecked, and I know a lot of you have been at this point, especially if you get up early in the morning to study. I love law, but there are times where I just want to be on the couch. I just want you to know that. That being said, we are now going to look at tort law, which was not asked in March 2020 because of the COVID, but which was asked last Thursday, August 2020. All right. So the first question was an essay question which said the doctrine of res ipsa has been the subject of various interpretations and applications, so much so that the time has come to jettison the doctrine altogether and restore the standard position regarding the burden of proving the essential elements of a tort. Critically discuss using relevant jurisprudence. Alright, so res ipsa comes under my chapter. Now, friends of the Law Hero, I do not cover res ipsa to a large extent in my ebook chapter 1, alright? And the reason is because it doesn't really come up a lot. It's a really strange or like an extraordinary situation whereby the court reverses the burden of proof and actually the defendant must prove they were not negligent. This doesn't happen often, and the case I give in my notes is Byrne v. Bodle, where flour falls on the plaintiff from a window above the defendant's shop. Now, this was obviously an accident, but then of course you can say, alright, okay, if it was an accident, where does the negligence come in? Who was negligent here? Were you negligent as the shop owner? Okay, you were. Now prove to me that you were not negligent. Okay, so I had barrels of flour here and they were near a window. There was a possibility that they could fall on a customer, but I took all of the necessary precautions that wouldn't happen. It's just, yeah, it's a hard one to prove, and I don't go into it in my notes. The other one was Hanrahan, Merck, Sharp and Dome, where the cows in a local field were actually ingesting the runoff of chemicals from that particular pharmaceutical company down the country. Look, I'll just leave it. I wouldn't bother. The kind of depth he's looking for, that level, I mean, it's so obscure, I just wouldn't bother with question 1. Question 2, I'm not going to go down through all of the facts, but it concerns two tenants in an apartment block. Both have done different things. So you have somebody who smokes on a balcony and lets the fag butts actually go down to the balcony below, and then the person who's in the balcony below is leaving their rubbish out in the apartment, which you're also not allowed to do. So what happens is the wind catches one of the butts, lands on the rubbish bag and sets it on fire. And the question is, right, where is the damage? So the damage happens to the lady below. Okay, so obviously because we're in the realm of tort, we always think of negligence. However, this is a different type of a tort, because here we have actually somebody who lives, even though she's a renter, she lives in her apartment. So that means she has a proprietary interest in the quiet use and enjoyment of her space, all right? So there is somebody interfering with that right. So it is not just negligence now. There is strict liability around nuisance. This is nuisance because of what I just described, wrongdoing on both of their parts, because it's not like it's contributory negligence because, you know, this is flat out nuisance, but her remedies or her relief or her you know, the amount of relief she's entitled to for the physical damage will be reduced because of her behaviour. Question 3, I'm not going to go into it again too much, but it is a practical joke in the workplace, and basically this lady's colleague, he says that there's a fire and she has an irrational fear of fire, and she loses her mind, and she suffers some psychological injury. So, you know, I would go down through psychological injury, and you know, the jokiness of it. You know, it's supposed to be a practical joke. Also, it's in the workplace, so there might be some vicarious liability here around her, you know, her safety as well. So yeah, they're kind of the 2 issues I would have picked out of that. That's question 3 on the tort paper. Moving along to question 4. Yeah, this seemed to be a straight passing off problem question, so I'm not going to go too much into that. Question 5. Now, this is interesting. So I don't really cover this in depth in my notes, but this is how the Defamation Act 2009 relates to new forms of media, particularly social media. And actually, I have an ebook, chapter 14 of my commercial contracts ebook, which is up on my website. All right, so I actually go into it there, and I might actually copy it over to the FE1. It's very detailed though. It's more for kind of, it would be more kind of PPC2, or if you did the IPIT diploma. But I said that a range of offences can take place on social networks, defamation being one of them. The Defamation Act, this comes under section 27, innocent publication defence, and section 40 of the Copyright and Related Rights Act. But you know what, lads, I wouldn't be getting too much into that, because don't worry about the Copyright Act, because that's not really in the scope of your exam. However, section 27 would be, and it says that social networks can avail of the defence if they took reasonable care in relation to the publication and had no reason to believe they were contributing to the publication of a defamatory statement. And this is useful if the network had no prior knowledge of the publication and then acted appropriately once the matter was drawn to its attention. And this is why you have all of this report abuse functions on blogs. This seems to have been a product liability defective part in a car, which I don't cover in my ebook. Now, question 7 seems to have caused a little bit of upset for people, but this was in fact an intentional tort under chapter 7 of my book, Novus Actus Intervenes, because he pushed against Murr's leg and he got hit by the drone. Even though the drone attack was meant for Terry, this was a Novus Actus, I think. Could have been foreseen that it would hit anybody. You know, there's no remoteness here because he had intended to hurt somebody. So yeah, I definitely would have brought that in actually. It's like Bolton v Stone, like, you know, that a cricket ball would hit a passerby. Yeah, I would look into that. Question 8. Evaluate the situations where the law may modify the general rule with respect to the limitation period for torts. Yeah, so limitation in torts is a defence. So it's the 1957 statute of limitation. And obviously, there are certain cases where tort will, where limitation period will be extended, depending on whether you had discovered the injuries, and this is for normally personal injury cases. Anyway, I've rambled on a lot. It was a tricky enough paper, but it was, you know, if you had covered my stuff, The other thing as well is defences. You always need to bring up, you need to mention defences in the problem questions. And I cover all the defences in the last chapter of my ebook. It's very, very important because there'll always be defences in tort, like concurrent wrongdoers, like I said in the first question, or there might be contributory negligence. Also as well, look out for the UCC v ESB case, which was about the flooding in UCC back in 2010. If you're not already subscribed, please subscribe, and please like this video if you have, and I'll see you in the next one.